member of the EPFO, or the Employees Provident Fund Organization, and actively contributes to key industry bodies including CII, EFI, and ISF. He's an advocate and the regional managing partner at AM Legal. With that, I'd like to hand it over to Mr. Sandeep to kick off the webinar today. Sandeep, over to you.
Thank you, Saina. Good afternoon, everyone. We'll have a similar approach as our last webinar. We'll continue with three broader buckets for these two codes: a broader overview and key provisions under each of these codes, limited set of questions which may haunt a lot of professionals around us, and actions which we believe that the employer should pick up immediately so that they can stay compliant under these two codes. Now, I'll be a bit fast on the overviews and key provisions so that we can spend time on questions. OSH code, very briefly, what it is doing, it is actually repealing 13 odd acts, 4 important acts which broadly are applicable to a lot of organizations are factory, LRA, BSOW, and ICT Act. And there are 9 other acts which is more dependent on the industries, which is applicable to a specific set of industries only, like mines, plantation, motor transport, journalism, BD, cigar workers, and so on and so forth. So now we have these 13 acts going away, and we have one code covering all of these put together. Significant change. We spent some time in the last webinar as well. What is the difference between employer and employee? Sorry, just hold on. From a definition perspective, it was very clearly indicated that a worker is a person who has been employed in, who has not been employed in a managerial capacity or an administrative capacity. And it has also included person in supervisory role who earns less than 18,000. The thought is very clear. Every person employed by an organization is an employee, but you now have a specific differentiation on worker, which was earlier from an industry perspective, very simple on blue collar versus white collar. Now you have a different definition altogether. How does it impact? Now assume that now the codes are also applicable to all industries, which is basically IT industries as well. We are saying that in an ITES setup, a junior developer who is not employed under or for a managerial capacity, he will also be a worker. Assume you have a finance function, you have a person who is managing your receivables or payables. He becomes, as an individual contributor, also a worker. So as an employer now, I will have to identify and categorize every person employed under 2 buckets: who is a worker, who is an employee. And now a lot of these are important things because it will impact the applicability of your standing orders, dispute resolution rights, layoff and retrenchment eligibilities, and compensation calculations as well. So this is something which will continue to haunt corporates for some time unless they are clear about how do you differentiate. It will also have to go back to their JDs and appointment letters and job descriptions. So things will evolve from a corporate perspective, but this is an important area which every corporate will have to think through. Now, very briefly, important features: applicability. It is applicable to all establishments now with 10 or more workers. Now, this is very clear that you're not talking about employees, 10 or more workers and not employees. So that both the codes, the word used is more workers rather than employees, right? And there is no relevance to worker headcount when an industry's establishment is involved in hazardous activities or dangerous activities. Specifically, if you look at factory thresholds, the thresholds have been increased from 10 to 20 for establishment who work on power, and from 20 to 40 for establishment who work without power. One important simplification that has been brought in is single registration. So the ministry has gone away with all the different type of individual registrations that the corporate has to take up. Assume I'm a normal company in a factory establishment. Bare minimum, I will take a registration under factories and CLRA. Now, I don't have to take 2 registrations. In greenfield projects, I start with the BSOW registration and a CLRA registration, and thereafter I'll continue with CLRA and factories. So in principally, multiple registration regime has gone off, and the ministry is looking at establishment taking only 1 registration. The thought is simple: any industry or establishment who has not taken any registration from on the date of when this code goes live or it becomes effective, they have to obtain these registrations within 60 days. Establishments who have obtained registrations need not apply now. It is expected that their existing registrations will migrate to the new system, or these licenses will be valid till the time the government defines next steps. Now, if we look at important provisions for working conditions or mandatory provisions, appointment letters are now mandatory. In the earlier labor laws, it was not mandatory under any law. The thought is that if the employees have not been provided with appointment letters within 3 months from the day of effective of this code, the appointment letters need to be issued. Again, annual health checkups now is mandatory for all employees above a specific age, again, which was not defined under any labor law earlier, except for Factories Act, which was also limited to a certain set of employees on the shop floor only. And we spoke on the license, it's a single license. More importantly, now safety committees have to be formed, and employer has to ensure that the representations are equal. And now the limit has been increased from 6 to 10, and it has to be equally represented by worker and employer. The female representation is also mandatory based on the proportionate to the number of female employees in the organization. And there is a requirement for safety officers to be appointed depending upon the type of the business and the headcount. So let's say if you're a factory, if more than 500 workers you have to appoint a safety officer. Similarly, if you're a factory established, engaged into hazardous processes, then headcount more than 250 requires a safety officer. Night work. Night work for women employees were earlier prohibited in general. It was allowed if there are specific exemptions for state government that too requires employers to provide stringent facilities or safety requirements like transport facilities, female supervisors, and so forth. Now, female employees are allowed to work on all type of work in night shift, which is after 7 p.m. to 6 a.m. Migrant workers, the definition has been expanded, and it now includes all workers moving from one state to another on their own. And there is an additional requirement of journey allowances once a year to visit their hometowns. Threshold for contract workers have been increased from 20 to 50. Core and non-core activities is something which is another area where the industries have to work on and ensure that if you're hiring employees through contractors or a contract employee, they should not be deployed on core activities. In principally, the notification has defined 11 non-core activities where the provision does not apply, and the government has the power to keep defining more and more activities under core versus non-core. Working hours, these are simple provisions, but more clear now. 8 hours a day maximum, 6 hours a week. And if you overtime, the overtime can only be overtime. An employee can be made to work overtime only if there is a prior consent provided by the employee, and they have to pay it twice the rate of daily wages. I think from a leave and compensation perspective, what is more important and critical is encashment. A lot of companies will get impacted because of the existing policies of leave encashment that they have today. Majority of the companies in India today, I believe, does not allow carry forward after a particular number of leaves, and no encashment is there, so those leaves gets lapsed. Now the provision of lapse is not there. Employees are eligible to ask employer to provide monetary benefits or the encashment for the leaves which is not getting accumulated or carried forward. This is the same thing that we have discussed, but a brief comparison of old provision versus the new provisions. The threshold applicability is now very clear, applicable to all establishments with 10 or more. Registration requirements is single registrations as against multiple requirements under multiple acts. Factory applicability, the threshold has been increased. There is a higher threshold now, increased to double from 10 to 20 and 20 to 40. Appointment letters are now mandatory. Annual health checkups are now mandatory. Night shifts for women are now possible for all type of work in all shifts subject to the consent and safety measures. clear definitions around daily working hours, and leave entitlement has been defined very clearly. So these are few important changes in OSH code as against 13 odd acts. Now, important questions. So we do have limited questions this time. We want to spend more time critically analyzing certain set of questions which we believe has a clear impact on every industry. I'll request Madhu, who is an expert on labor law and employment matters. First important question, I think, which I believe every company today gets impacted with, irrespective of the industry, is worker versus employee. And it is a complicated matter, specifically when it is very difficult to ensure that who is a worker and who is an employee. How do you keep ensuring that you are able to prove when you define somebody as a worker that has to fit into a certain set of parameter that has been defined by the law? So showcasing that parameters have been adhered to a labor inspector becomes critical, and then ensuring that now you have two set of policies. So I'll jump over to Madhu. What are the important parameters, and then how does it impact employer in general?
Thank you, Sandeep, for having me. And yeah, this is a very important question. I think from the beginning we've been harping on this, and why it is important, because as we are calling now the downstream compliance requirements, right? Take OSH code, for example. You talked about leave, you talked about health checkup, you talked about safety officers. So the thresholds related to when you need a safety officer, or threshold related to whether a particular establishment needs a cafeteria, a canteen, all of them are based on number of workers you have. And and also, so leave, for example, leave encashment, leave that you need to provide. It's all about workers, right? It is not that such benefits as per OSH code. That's what we are discussing here, is for workers. Employees are mentioned in OSH code, particularly only when related to safety. Otherwise, every other benefit or this thing, or even threshold for whether you are a factory or not, and whether you are an establishment covered under the code. For example, any establishment employing 10 or more workers is what is covered under the act, right? Code. So yeah, so it is very, very important for every employer to know who is among your 100 employees, for example, is worker. And what goes into worker is a very important aspect. As per the definition, anyone who is performing a work of a managerial supervisory, administrative nature, will not be a worker, right? So that is going to be, so as you rightly pointed out, I was just doing in fact, that's why I got late into this, reviewing with the client, and then we were going through all the JDs, right? There is this JD about finance executive. If you read the role that he is doing, it's very clear there is no managerial this thing in that. Can somebody who has to make a decision as to whether this is an invoice that needs to be posted, whether this is an expenditure that has to go to particular code in accounting, can we really call it managerial or administrative? And if that is the case, where will, because today we are very conveniently taking such a person to be an employee because he may be drawing some 30,000-40,000 rupees. So you have, as you rightly pointed in the PPT, the threshold of 18 is applicable only for a supervisor. Only when you are deciding whether a particular person who is a supervisor, whether he is an employee or not, is where the threshold applies. Otherwise, a normal worker, the example I told you, a finance executive, even if he draws 50,000 rupees, if he is not an employee engaged in managerial administrative nature of work, then he is a worker. So we really have, as employees, we all have a definitely task on hand to really look at each of our JDs. You rightly brought in the JDs also, and see whether that, and it has to test, it has to pass the test of tomorrow. If you, let's say, you didn't take a you didn't take a factory's license because a particular person is not considered as an employee, therefore you didn't follow the threshold. Tomorrow that test will be, probably the administration will take you to the court, and then court might decide. But there you need to be able to prove that yes, all these people are employees and they're not workers, therefore I didn't take it.
Right. And is there any clarity available today when we define? So managerial capacity is clear, but what do you mean by administrative capacity or administrative matters?
Yeah, unfortunately, there is no clarity, there is no definition, there is no clarification, and I'm not sure government will come with a clarification. Though I think every industry organization like CII is also ask for some of these clarifications. We have been giving FAQs. Let's see how the government is responding to it. But we have to be very careful, mindful of the fact that we are living in a country where Supreme Court itself said a pilot is a workman in the old regime. So will what we call the jurisprudence or that ratio of Supreme Court will be applicable in the revised new environment? Some of the logic will still be applied, right? When somebody goes and argues this, they might bring this up and then say a finance executive is doing administrative, and suddenly the other side might throw the case saying that this is what Supreme Court held and a pilot was held to be, and not a managerial administrator. So there is no guideline, unfortunately, but I think we all need to use our own. I think it is more common sense. For example, if he is somebody somebody is reporting to him, and also see in that job description itself, we kind of add elements which bring out the aspect of decision making, discretion he needs to engage, etc. So I think that's the thing. But unfortunately, to answer your question, there is no clear-cut guideline as to how do we distinguish an employee from a worker.
Right. And I think there was a mention on wage ceiling that is also relevant only for supervisor.
Absolutely.
Is there a definition available for who is a supervisor, or is it very clear? It can be interpreted that supervisor is something in the blue collar job and it's not relevant for a white collar jobs.
Yeah, so supervisor, again, so it's all, since there is no clarity, it all depend on how these terms have been interpreted by courts before, right? So supervisor generally is in the industry parlance, particularly in manufacturing unionization, it is somebody who had the power to grant a leave, who had the power to, for example, terminate or assign shifts like that. There are multiple criteria used, and then courts were presented with that. Based on the courts have taken a decision. So if you want to call somebody a supervisor, you need to be mindful of all those things and then accordingly do the categorization.
So we're saying we'll have to wait and watch. There more clarifications will um, be provided, and I think the industry will evolve with examples
Yeah.
or judgments and
Yeah, I do think that the extreme example of pilot being a worker will get moderated, because I think their impact here is going to be much higher, because there is an aspect of overtime, all of that, right? So
Correct.
somebody, let's say we are hiring who is being paid 3-4 times the minimum wages fixed for that role. And then on top of that, you are saying they have to be paid in overtime because he's strictly a worker. I think therefore the opinion even by the courts might change. But yeah, but then we have to be really careful about how do we do that, being unmindful of that, and then calling everybody who as an employee whom we continue to so far call an employee. We have to be careful.
Sure. Now, if you look at today, a lot of establishments actually engage contractors and they hire people through contractors and they are deployed on different type of work. Now, since the ministry is very categorically talking about core versus non-core, what do you think an entity and how do you think an entity should reevaluate the engagements to classify these core versus non-core and decide whether a contract labor is permissible or it can be deployed onto a particular activity?
I think this is also another very important thing. We all know contract labor is used very prevalent in today's industry, particularly in manufacturing. Some of the government statistics itself say in manufacturing, out of 100 jobs, 75 jobs are given to contract labor. And while the contract itself may not say whether it is employed core in the core activity, but the contract labor in truth might have been employed in the actual manufacturing process, right? So I think the employers have to be very careful, but you can also take comfort under the fact that there are three exceptions provided by the particular section. One of them being contract labor if they traditionally been employed to perform that work in the industry or in a particular establishment, then that can continue. So then your employers have to really look at whether that will be applicable to them. But I think it will also be good to exercise caution and be careful about in the arrangement. So do a review. Where are the contract workers working today in your activity? And it is true of services companies also, right? For example, I was sitting with a client and then they were there into merchandising, that they provide support to retailers. How do you keep your merchandise in a retail shop, right? They're experts in that. But they have a lot of people who go and work in the client retail stores, right? And some of them are full time there. So they are taking a very generic view that no, merchandising is not a core activity for, let's say, a garment manufacturer. I think probably it is true, but evaluate that, be clear, and between that merchandising expert company and the retail or the brand, they need to have that discussion, and then they be both of them be sure that this is actually not a core activity. See, if you, for example, that 11 activity listed may not be, they may not cover this particular activity, but will it therefore come under the core part of it, which is any activity necessarily connected to the core at the business of the establishment? It is possible the authority will argue in the specific case saying, boss, for you to sell your clothes, you need to know how to organize your store. So there is, therefore, it is a core, right? But today, in the way business is conducted, we can always say manufacturing and getting the cloth ready or the garment from cloth to garment is the core activity, and selling is also core activity which is being done. But this is just an arrangement of my product in such a way. So you
Correct.
need to be
I
prepared for
think since
those.
you mentioned services, I mean, a lot of tech companies today also actually hire specialized staff from staffing businesses, the staffing companies.
Correct.
So IT companies hiring senior technology developers or junior technology developers, technology being the core, now it becomes difficult.
Yeah. Yeah, so there is another important aspect. The definition of contract labor has gone through a major change. There is a, to the existing definition, they have added one inclusion, which is the interstate migrant worker. Then there is an exclusion, which is the employee who is regularly employed by the contractor, who is normal treated as a normal employee, given increments every year, and then provided social security is not included. So in an IT situation, you may be able to do that. For example, a big, but then in an IT staffing company, can they claim that exemption? But probably they can. And if he is continuing, if he is the full-time employee of the provider, contract provider, and the agreement between the IT services staffing provider and this about services, probably there is an opportunity. So you brought out important aspect, and so it needs to be really understood, not only from the context but also some of the small changes. Of course, it is not a small change, a big change, because that exclusion is an interesting big exclusion, and therefore and the employers have to take that call after studying all of this.
Right. Now, this can be a simple question, but critical. I mean,
Yep.
now is there a problem statement who is a contract labor, or it works in as per the old thought processes?
Absolutely. So one aspect I already
Mentioned.
explained, that is the exclusion. The other aspect is with regards to the services being provided. And if you really look at the section 45, 1 and 2, which is what is the defines the applicability of the chapter of contract labor in the OSH. And it says 45.1 says that in a employer of establishment where more than 50 contract labor are employed. So if you are a person whom you have engaged and is not part of the contract labor definition for the reason I told you earlier, then that 50 may vary. So you need to look at it that way. Second aspect is, the second part of it says for any manpower service provider who engages more than 50 contract labor is when the chapter applies. And therefore if, for example, an MSME who's not engaging more than 50 contract labor, for them it doesn't apply. But at the same time, an MSME hires contract labor in any case, and that contractor is engaging more than 50 contract labor across, not only with him but everywhere, then he needs to be sure that that contractor has a license. That's one. Second, the can, like the IT services example you gave, it could also be, say, for example, in a factory, you have a large cooling installation, and then you have a contract with a service provider who maintains that. I'm not wanting to call it simple AC, but sometimes let's say a cold storage thing, right? And then he deploys people, and that is a services contract, and it is all SLA based. That the cooling system should work. There shouldn't be not be any downtime and all of that, because of which somebody is engaged, and then he is engaged by the service provider on a as his normal employee, then that also comes out as an exception. So now it is not contract labor as we typically understood before the code. Now the whether somebody is a contract laborer or not has these variations to think through and understand. Probably you have an opportunity to document these things in such a way, and therefore that you need, while it may be in our traditional sense a contract labor engagement, but truly within the definitions and changes that has come up in the, it may not be one. So that's what somebody has to be, an employer has to really do and a study, for example, and then understand where he stands.
Is there a requirement of a principal employer registration for hiring contract labor? I think you answered this.
So I just wanted to add one more thing, is that we need to be watching out for the labor rules that are coming out. In the central rules, which has come out very clearly, the form that is required for obtaining a license in most parts is aligning with with the fact that principal employers do not need a registration. But the fact is, there are a few questions asked in the form. It somehow links the principal employer. Of course, as industry bodies, we are yet to go from CII, but we are going to submit that as one of the feedback, and that has to be made clear. But definitely, this intent of the OSH code, that's a particular chapter, is that principal employer doesn't need a registration either to as required either to. Going forward, it is the contractor who needs a license. But how will the principal employer come into the picture? Whenever a contractor gets a mandate from a principal contract from any principal employer, the act and the rules requires the contractor to update the licensing authority saying, you gave me so much license, out of which this many are engaged in this particular principal employer. Unfortunately, in the forms under the code, this thing, that particular form is missing, though there is a rule which says that it has to be updated within 15 days. So principal employer is going out of the mix from a regulation of contract labor perspective.
Okay. Now, there is an addition for payment of journey allowance to interstate migrant workers. Will this be a taxable component in salary structure, and will it be also applicable to white collar employees who are earning more than a threshold or a ceiling limit?
I think taxability, definitely there is no doubt about it. But 18,000 and today's 12 lakhs, this thing probably no typical interstate migrant worker may not come
It
under.
does not impact at all.
Yeah, but then the point is journey allowance. If you read the rules, draft rules given by the center, and then if all states were to follow, it's a little complicated. What it says is that one interstate migrant who works for more than 6 months has to be given in the journey allowance, which is from the place of his work to his village or town, wherever he is coming from in a different state. Now, the requirement of the rule is that if somebody worked for you more than 6 months only is eligible for, but it also says if the particular interstate migrant worker gives you certificate, my earlier employer did not give. So for that also the current employer has to give, which I don't think is a right requirement. It will complicate things for everybody. And therefore, I think definitely as a feedback, we are going back from CII, for example, or ISF, where I'm part of some of these discussions. So we are going to give a submission saying, please don't do this. If a particularly is with one employer for 6 months, that employer should be made to compel. If he has now started jumping 2-3 places, and then for fourth place he goes and gives a certificate, I worked for these people, what is the responsibility of this current employer? Does he have to go check and all of that? And no, I don't think that's a fair requirement. But be aware. I think employers on this call should be aware that there is this requirement. So be careful. And in any case, one of the most important preparation is you need to know how many of your workers are migrant workers, because that will be an important aspect, because there are a lot of data requirements. There is a specific section which requires the employer to give data to any authority, probably NSSO. They might start coming asking for specific details about the migrant workers. So it is better for the employers to have the data with them.
Now, if you look very briefly on the important actions that every corporate has to take, immediately issue appointment letters to all employees, ensure that you plan for free health checkups for all employees. Over time, get aligned to earlier thought process, but I think what is new is ensure consent. So I think documenting this consents are more important these days. And for women employees, I think arrange transport, security, female support. I think that's probably with every companies have been doing. On an ongoing basis, you'll have to get yourself registered if you're not registered under anybody. And for migrant worker, portability benefits has to be claimed. So these are important actions which companies should look for. I know these are not very complicated areas. There are other gray areas where we talked about employee versus worker. All of that is also immediate. I have not mentioned it here because it might be time consuming and there's a bit of gray area on how to define and segregate and categorize employee versus worker. Now with this, we have actually, we will jump on to IR code. Before that,
Yeah,
Sandeep.
maybe I'll just come in. Thank you so much, Sandeep and Madhu, for this detailed explanation on the OSH code. I think some of these questions are there on everyone's mind. Just before we move on to the IR code, there's a question that's flashed on your screen. If you could just go through the question and respond. Maybe we'll give it a few seconds, 30 seconds or 45 seconds for the responses to come through. So I think in the last 2 months or so, there's been an information overload around labor codes. And a lot of people have started transitioning or have started working towards this transition. So the question just generally asks around what the biggest challenge is, at least that you perceive today to be, when you're looking at the entire labor code implementation. Okay, I think see the responses. I'm not sure if the audience can see the responses, but I'll just call it out. Wage definition and salary restructuring impact is the biggest challenge that employers are facing today. About 59% have voted for this, followed by payroll system and compliance readiness, which is 19%, and then followed by the gratuity and social security cost implications, which is around 18%. So I think everyone has started this work with the wage definition piece, which is why it's there on everyone's mind and it's there on top of everyone's mind. I think the gratuity impact is a big one too. So companies will have to sort of see how to bring that impact coming in. But it's interesting to see, the mindset and where people are today.
Yeah,
So
the
with
communication part seems not but I think that's where the challenge will come, because once you complete your structuring exercise, you have to go and explain. No, that's. I think people.
I think that's just at the end of the spectrum, right? So,
I think
people are going to start thinking about
from
it.
an activity also, it is at the end. Probably people are still not started thinking about it.
Yeah, but good to know, the mindset of where people are at today.
Immediate
Back
pain
to
seems to be the structuring of wages.
Yes, absolutely. Back to you, Sandeep and Madhu, on the IR code.
Thank you. Similar in IR code, if you look at it, that's got Field Industrial Dispute Act, trade unions, and industrial employment standing orders. And the code is it's basically focusing on balancing employer flexibility with worker protection. Now, if you look at industry definition, I think now it is very clear from a definition perspective is any systematic activity organized by cooperation between employer and employee for production and distribution of goods and services. So I think the thought is very clear that there has to be a nature of employment arrangement between employer and employee, and the profit motive is not important for that perspective. Emphasis on employer-employee relationships. I think it has upheld and thought that there is a Supreme Court judgment based on which I think it has been picked up separately. Now, if you look at important provisions under around industrial disputes, they have defined what is strike. Concerted mass casual leave can be constituted strike, but now it requires a 14-day notice for lockouts and strikes, and the validity of notice has been increased or changed from 6 weeks to 60 days as well. Grievance redressal, it is important that the grievance redressal committee members have been increased from 6 to 10 members. Time period for filing grievance has been reduced now from 3 years to 1 year, and now it does not require notices for important emergency situations like shift changes. No notice is required. Retrenchment and layoff, factories, mines, and plantation. I mean, now they have to obtain permission for retrenchment or layoff. The threshold is increased from 100 to 300, and the employers have to contribute 15 days of wages for each retrenched employee around worker reskilling fund. Standing orders now applicable to all industrial establishments. Threshold is increased from 100 to 300. Central government will draft model standing orders, as again the previous requirements of both central and state had that power. Now it will be only central governments, and there will be a specific authority. Appropriate government. Central government will now be the appropriate government for 3 industries: telecommunication, insurance, and banking. And employers will have to consult to trade unions before submitting these draft standing orders. We spoke on the reskilling fund. Certification, the expectation is that if it's not certified within 16 days of the application, it's deemed approved within that post that 60 days, and the existing standing orders will continue to stay in force. Grievance redressal committee, if you look at the structure of the committee is simple. It has to be an equal number of members representing the employer and worker. The member limit now is increased from 6 to 10, and the chairperson also rotates annually between employer and worker representatives. Women representation, there has to be adequate representation of women proportionate to their employment numbers as well. So the thought is now the committees now are represented by all the relevant parties. Timelines are simple. The workers can file a grievance within 1 year. Committee has to complete the proceeding within 30 days. And so the process is that the worker will have to first submit a response to coalition officer and wait for 45 days. If dispute is not resolved, the worker may approach the tribunal. Now, since the worker now has the ability to directly approach the tribunal, tribunal now is been given full authority to judge the case and close it. Brief comparison, standing orders now applicable to all industry establishments, but higher threshold, 100 to 300 has been increased. Retrenchment, closures or layoffs, again the threshold has been increased from 100 to 300. Worker definition, we spoke in depth. Strikeouts, mandatory notice periods, 14 days notice is now mandatory for all establishments, unlike earlier it was applicable only for public utility services. Trade union recognition, so it has now introduced a clear framework. The concept of sole negotiating union versus a negotiating council has been introduced. So there is a structure process now. And we spoke on the redressal committee and the restructuring fund as well. These are important questions. Grievance redressal committee. Now, question is simple. Practically, if a company is a small company with just 20 workers or so, how do you constitute a committee and how do you run this committee? And from a question perspective, who can be members and how do you ensure equal representation? These are simple questions on the practical.
Yep. So I think grievance redressal committee is a very significant change. And with the discussion that you had about what is industry, And that's where worker is very important. The concept of whom your worker, whom among your employees or worker is very, very important. So even a small company, let's say when I say small 150 employees, and you have, let's say, only one establishment, one office, and if you're not really sure about among yourself, and you say you don't constitute a GRC, but eventually there is a dispute, and then it is proved that more than 20 of your employees or workers, then there is a gross violation. And IR code violations are very expensive. Minimum fine is 50,000 rupees. So having said that, how do we constitute and constitution has very strict norms, right? It is up to 10, so you can have a lesser number also. But then you need to ensure there is a equal representation, and also there should be proportional representation for women. Now, that's so these are all very complicated, this thing. And the IR code rules at the central level supposed to have prescribed how do we constitute this, and then there is this concept of negotiating union, negotiating council, and all of that stuff. So the unions have the right to nominate. Now if we don't have a union, how do we do it? How does the employer do things? So there are the standing IR rules from the central this thing, which may not be really relevant to many of us. As you rightly said, central government is the appropriate government only for those major big industries like telecom, banking, and all that, which are regulated by the center. So we will have to really go by what the state governments come up with it. And if you don't have an union, and how do we ensure this thing? How do we elect the employee representative? I think there will be a lot of discretion to you. Probably you can use your own internal polls and all of that stuff. That's how you need. So I think so long as you make it practical, at the same time, not something imposed on the employees, or at least that is not how it is seen, then I think you should be able to be compliant with this. But I definitely agree this is going to be a complicated issue. If you don't have one, it could be non-compliance. If you have one, and then it is, in fact, if you really look at how the decisions are made, the majority of the employee representative should have agreed to a decision. Then only it's a right decision. Then only it is a decision of the GRC. So it's really complicated. So if a dispute were to be referred, and among employee representative there is no consensus, or among them there is no this thing, the GRC cannot actually settle it. So we are in for interesting times when it comes to GRC.
Right. Now we're back to ITS company. I mean, the question is, if I'm managing ITS company, I have employed more than 300 employees. I've now never gone for standing orders before. So can I simply adopt the central model standing orders electronically?
Yeah. One is whether, again, the same question, do you have 300 workers is what is going to be important. So if all of your employees are not more than 300, I think then you don't have to really worry about it, because even if all of them were workers, it is not applicable to you. Let us say it is applicable, or you are in doubt, then the best option is, as into the schedule to the IR code, there are 3 model standing orders which has been annexed, and one for mining, one for manufacturing, one for services. So the simplest way to comply with this is that you can electronically communicate as per the central rules to the appropriate labor commissioner, saying that I am adopting the model standing order. What does model standing order provide? It provides for many things, right? For example, in services sector, it is even provides for work from home, all of that stuff. But does model standing order provide for everything that you can think of in a normal working environment? Probably no. So the best course would be take the model standing order, whatever is not applicable, make an amendment to it. Even if you're not unionized, probably ensure a representation from employees, and then take their views and then do the certification process. Unlike earlier, I hope that comes to reality. Unlike earlier, because today there are companies which have filed for certification of standing order, they're waiting for 20 years and all of that stuff, right? And the IR code definitely puts a deeming provision. So if you applied for it and it is not, let's say, certified within a period of, I think 60 days, then that is considered approved or certified. And there are time limits prescribed for the officer to come back, constitute a committee with the employees so that it is approved, etc. So easiest way will be to adopt model standing order, or more practical way will be amend the standing order, apply for certification, and once, even if doesn't go through all the processes, but by the mere fact that the time has lapsed, it is deemed certified, and then you are compliant.
Okay. I think the last question I have on this is, what kind of processes as a company we should have for retrenchment now? And
Yeah,
do we
so
need to take
that's
a
sorry, a very important question. And it's no longer the case that I'm not an industry, therefore I don't have to worry about it. It is very clear now, everybody is an industry. So if, let's say, an ITS company, because of say not doing well or not enough order, they want to retrench, then you have to be, again, the threshold is 300 workers for you to take a prior approval. And only IR code applies only to workers, right? So if you are very confident all your employees are not, none of your employees are workers, then you can live as normally is now. You can actually fire them and really don't have to worry about it. But be careful whether that stand is sustainable. Is it possible that a company will have no workers? And if they are considered workers, then the provisions that you read about, retrenchment compensation, etc., will come. Prior approval is only when you have more than 300 workers. So that may be, and it also goes by establishment. So even an IT company having multiple establishments, in each establishment they don't have more than 300, they can technically argue out saying that it doesn't apply to me. But preparation, be aware of this, ensure that you do a regular review, not only at the time of implementation of the labor codes, but otherwise as well. Where do you stand from a perspective number of workers? And if you are actually, it's not just a business decision that company is not doing well or market is not, say for example, you are a very, very focused one on, let's say, Python as a this thing, that's possible, right? And then that language as such is going down, and therefore you want to. So it is not only for the business guys to be aware of. I think you need to keep your HR and IR teams also to be aware of. Boss, be ready. We are seeing this. We may have to do something about it. So be prepared. So I think that's what I keep saying now. HR and IR are moving slowly towards boardroom because of the codes.
And we have recently heard of large IT companies laying off a lot of employees. I mean, those news will not be so easily heard in future, right?
Correct.
Okay, now jumping to important areas. I mean, as we discussed, GRC have to be designed and adopted for 20 and more workers. Policies have to be reviewed to ensure that the 11 requirements have been plugged into the strike or lockout policies. We have to look at the retrenchment procedures as indicated by Madhu now, and then adopt the standing orders if relevant for more than 300 workers. So I think these are important areas apart from other requirements. We'll have one more poll, Anya.
Yes, we have the second poll and the last one for today. And this is just to understand your readiness around the labor codes. Have you already started? Are you fully assessed and implementation is underway? Are you assessed, but you're planning to start the implementation, or you're in progress when it comes to the implementation? Are you early on in the discussions at the moment and haven't yet started the assessment or the implementation, or completely not started and just waiting for clarity at the moment? So just want to get a sense of where the room is in. We'll give it a few more seconds and then we'll flash the results on the screen. Okay, I think the results are out. So most employers, at least who've come in for this webinar today, have the impact assessed and implementation is in progress. So the work has already started, and the second major group is early discussions only. So very few, about 8%, are fully assessed and have have the implementation ongoing at the moment, and about 12% who've not started at all. But majority are pretty much, in the road, on the way, trying to assess and complete the implementation as we go along. All right, I think we've reached the end of the webinar today. We do want to spend a few minutes looking at some of the questions that have come in from the audience as well. So maybe Sandeep and Madhu, if I can just direct a few questions at you from what we've received from the audience. So I think the first one I want to pick up, and I think this is from Mr. Sunil from ITC Infotech. This is regarding the annual health check. So the code has not included commercial establishments, but has mentioned factory and BOCW. How to interpret the applicability specifically for IT and ITES?
No, code, I think, unfortunately, that's not the right way to look at it. Code is not excluding shops and commercial establishment. I think there is an element of discussion going on, which I've also noticed. The appropriate government definition, there is something related to uh, factories and BDN workers and other establishment not mentioned above. The appropriate government says so. Some people are interpreting that not to cover substance. I don't think that's right. It is covering every establishment. So any establishment which has more than 10 employees is an establishment coverable under the OSH code. That definitely brings out the Shops and Commercial Establishment Act vis-a-vis OSH code, how to interpret. So where could be contradictions coming between the two is that leave benefit, etc. Because if you are a worker, then the worker is entitled for benefits under the OSH code. Now, how do we resolve the conflict between OSH code and the respective shops and commercial establishment? There is a section 120 in the OSH code which very clearly says OSH code supersedes any other act already in place, right? But then if you have an ITS companies, that's where the question is coming. Most of your employees are not workers. Then the code provisions with regards to leave, for example, is not applicable to them. So in that situation, the shops and commercial establishment is applicable because they cover the IT establishments in any case. So you cannot take a very generic call to say that ITS establishments, the code both IR and OSH is not applicable. I don't think that's right, because as we discussed, what is an industry, how it is defined. Therefore, what is an industrial establishment to which the both OSH and IR code is applicable. The way they are defined, it covers almost every sector of the industry, whether it is IT, ITS, services, retail, and manufacturing.
Yeah, so I think it's primarily to look at the definitions that have been put out across all industries, and based on those definitions, kind of apply whether, something will be applicable or not in that respect. Okay. The next question is around the recent FAQs that the government has released in December. So that says that the contract laborers can be deployed in core activities as well. So maybe if you can share a little bit of clarity around this one.
Yeah. So that's what the contract, the section 57 of the OSH code very clearly says contract labor is prohibited in core activity. And then there is a definition of what is core activity. I mean, that is non-core, and then anything other than non-core is considered core. But then the same section gives three exceptions. One of them being traditionally such a work has been carried on through contract labor. That's what the FAQ refers to. Because there is a why did the government come up with something like this? Basically because there is a concern about too much contractualization happening, in particularly in manufacturing. I'm told more than 75% of workers in manufacturing today are employed through contractors. And so what is the way to reduce it? Probably prohibit this thing. But at the same time, fixed term employment is an option given to employers to kind of mitigate that risk, right? But then the intent of the government is not to stop it as of today, but give the existing arrangements to continue. So that's where the FAQ clarification has come in, which is nothing but restating what is provided in the section 57.
Understood. Thank you. The next one, if the work was traditionally done by a contractor, is there a limit on the engagement for those contractors, and how will the employment claims be dealt, if any, raised by the contractor?
Yeah, so long as you fall in the exception and you are eligible to continue to engage the contractor, I don't think situation has changed much from the earlier situation, right? So, what is the current court rulings in when it comes to contract labor and then claims of the contract labor against the principal employer? So long as it is not a sham contract and so long as you are complying with the requirements of registration and other compliances, then you are complied with every other requirement. For example, you have hired the contract labor through a licensed contractor, and the licensed contractor ensured that he has paid all the dues, and your proper contract between you and the contractor to get the manpower deployed to you. All of this are which is currently also courts consider when such claims come. So that will continue to be the case.
The next one is again on contract workers. Will ISMW also apply to contract workers or the interstate migrant workers?
Yeah, so what they've done is the earlier Interstate Migrant Workers Act was a separate act and it defined migrant worker in such a way that they go to somebody in his own state and bring them and deploy them in with his client in a host state, then only it becomes migrant worker. Now the one more aspect is if the migrant worker came on his own, is also a migrant worker. But they just done away with ISMA. The act is repealed. It's no longer there. Just added one sentence into the definition of contract labor. They says that including any interstate migrant worker. So if your contractor brings in any interstate migrant worker, then he is part of your overall contract labor. Everything you need to comply, except the additional requirement that you need to pay a journey allowance. So you need to ensure your contractor pays the journey allowance. And if he doesn't, probably there will be a recourse to you as a principal employer.
Thank you. This next one is from Sumit Mukherjee from Aditya Birla. Under Schedule E of the Code on Wages, the category of employees are mentioned under each skill category. Will this be considered as workers? Around 570 designations were categorized under unskilled and semi-skilled and skilled category. So maybe if you could share a little bit of light around, this.
Yeah. Sumit, this is out of syllabus because this is OSH and IR. But yeah, we will still, but it's an important, very important question because there is a Schedule E which is published by the central government in the draft rules published for stakeholder feedback for under the Code on Wages. And they do describe the what are basically they are categorizing who is skilled, who is not skilled, and all of that stuff. But can you assume just because let's say a carpenter is listed in that, and just because that is mentioned he is a worker, I doubt, because if you really look at the same rules, the central government draft rules for code on wages also defines who is skilled, who is unskilled, who is semi-skilled, and who is highly skilled. If you look at it, the semi-skilled, I mean skilled and highly skilled have a mention of anyone who is have the capability to supervise, right? The moment you be capability to supervise, and if it is above 18,000, then he is not a worker. So you cannot, just because a particular job title is included in that Schedule E, rightly so, some 500 plus, you cannot assume that he is not an employee and he is a worker.
Thanks for that. I think I have another out of syllabus question, but this one is also something that a lot of people are talking about. So, can we go live with the revised salary structures in April 2026 since it is the new financial year?
I think for team leads itself, we are doing quite a few mandates. This is one question we are finding it very easy to answer, but very tough to explain. Let's say, because I think it's very clear 21/11/2025 is the date on which all the codes are implemented. Now, which are the provisions which are dependent on the rules, where the government is saying by April we will complete the process of rules, which central government has started by publishing the draft. They are waiting for feedback from stakeholders like us, and then they will finalize. Probably it will take this thing. If you really look at it, the wage definition doesn't depend on rules. So wage definition doesn't depend on rules. Your Payment of Gratuity Act is repealed. So if somebody is leaving today, on what basis you will pay him gratuity? It has to be based on new wage definition, right? So to that extent, I think we all need to be clear. The date of implementation is 21/11. Now you can counter and ask me, no, but then if let's say government does do something about it, and then they are giving us time, there should or any other opportunity to lessen the risk of, I mean, cost of gratuity, for example. Yes, so one option, I'm not saying it is very legal, but is probably continue to settle gratuity as in the old basis, and be prepared to pay the differences once you are very clear, okay, the gratuity has in any case to be paid on the higher wages, and then pay the difference back to the employer. What will be the risk there? Of course, you are in violation of the strict compliance requirements. But what is the remedy is that the rules require you to pay an interest for the delayed period. So let us say somebody is leaving on 31st January and then you are paying him gratuity on old basic, but he is entitled to this thing. So let us say you sort everything by 28th February, 1st March you are paying. For 1 month, 1% interest you will have to pay for the differential amount. So this is a very, very practical approach. So you need to be, you need to take a call. But we do see some of our clients where we are advising taking this as a stand for
Understood.
gratuity. Then ESIC could be a different answer. There is a spree, which is an amnesty scheme going on. So you enroll them. As of now, you will not be penalized for you be not being compliant from 21/11/2025.
Okay. Is an external member required for the grievance redressal committee, or it
No,
will
no,
be
not required.
internal members itself?
So what you need is employer equal representative, employee equal representative. The chair alternates between employer and employee every year. And then women, if there are any, then what to the extent they are available in your workforce, same amount of representation they need to be given in the GRC. But there is no, like in POSH, there is no requirement for an external committee member. No, that's a bipartisan internal committee. The intent is not to bring anybody from outside.
Understood. Is compensation restructuring possible in light of Section 124 of the Code on Social Security? I don't know if you'll have that.
No, no, I know that 124 clearly prohibits reducing wages for the sake of restructuring those. That will mean if it has an impact of reducing wages. So you need to look at it two ways, right? One, let us say because of the application of age definition, based on your current structure, suddenly the amount that you calculate PF on, that you calculate ESIC on, that you calculate, let's say, overtime on, everything comes down. That's not you restructuring it, that's how the law applies. So that, in my opinion, very strongly, I feel that it's not in contravention of Section 124. But let us say if you, let's say, your basic itself is more than 60%, more than 50%. And whatever exercise you do, your new gratuity will be to be based on 60%, correct? Now you cannot go and say that I will restructure, reduce my basic to 40 and add one more allowance, and therefore I will start paying gratuity on 50%. That is definitely in violation of Section 124.
Yeah, understood. I think that's fairly clear. The next one is there's an ambiguity between the definition of wages in the actual code versus the FAQs that have come out. So, will the ministry issue any sort of a formal clarification or an update to the FAQs that have come out? What are your views on that?
Very good question. See, at the end of the day, what is the importance or relevance of an FAQ, right? So FAQ, government, let's say, gratuity example. Take my example, for example. When I retired and I was paid gratuity on my basic. Let's assume that I retired in 31st December 2025 and I was paid probably my employer applied, did not pay me the same basic instance I'm saying, right? Or I had a special allowance in my package, right? And then my employer included special allowance, let's say, in the exclusions, because that is what FAQs indicate. That's not supported by the definition as such. That's what FAQs indicate. So we can take it as a direction or directive or a suggestion by this thing, and accordingly they do it. And I get, instead of getting paid on a, let's say 60% or 70% of my gross wages gratuity, I get paid gratuity on 50%. If I were to take the my this thing to court, and then what might court interpret at that point in time? Will the FAQ persuade the court? It's an important question, right? Uh, if you really look at the definition of wages, there is every chance that court may not agree with the FAQ interpretation, particularly on components like special elements. But I think the way, but I can also argue the other way, because the one of the exclusions is some paid to defray special expenses entailed on the job. So an employer, if he comes and defends before the court saying that, hey, you yourself said special, my allowance is actually for that. I don't know what his special expenses are, but I'm just giving it. I don't know. Will that be a persuasive argument before a court? We'll have to see how that works. So there is no definitive answer to it. I will only say that if the FAQ published by the government suggests a certain aspect, I think we should kind of look at it as an intent, because at the end of the day, did the government intend that way, or did the parliament intend it that way, is an important question the government, I mean, courts consider when these kind of disputes arise. So the central government's FAQ will be very, very suggestive towards that.
Yeah, I think there is a bit of gray area around
Absolutely.
this. Yeah. Okay, maybe last question, since we're 10 minutes or 9 minutes over. Is the GRC required in a ITES company where you may already have a structured employee relations team handling grievances?
Very good question. I think that's very important for all of us to this thing. Yeah. So now I think the question itself very clearly says things that the IR code is applicable. They have to constitute an GRC. So if they among their this thing, if they have more than 20 workers, then they need to constitute a GRC. Now, that's the argument of the industry. I think industry is also going and pushing government to give them an exemption towards this. But will your any harassment policy, any mechanism you constituted to take care of such issues internally? I mean, many IT companies, they do function well. They are well constituted. Probably some of them even have a committee. If you don't have a committee, and then you don't fall with the requirements like it is to be equally represented, there should be alternating chair between employee and, I mean, worker and employer. All of that, if it is not, then you are not complying with it. Probably then, if you need to upgrade whatever systems you have to meet the requirements of the GRC under the IR code. Otherwise, you cannot claim I already have it, so I don't want to. I need not constitute one.
But if their current systems or the committees that are set up, if they meet the criteria of the
Absolutely.
grievance redressal committee, that can
That
constitute,
can,
or that can be
yeah,
used
it,
as.
it can be considered as compliant because they already have something in place.
Understood. Thank you so much, Madhu. Sandeep, anything from your side before we close?
No, Sanya, nothing. I think we covered briefly on and I'm sure there are a lot of open questions that all of us has together with me
Yes.
and Madhu. So I think we'll have to wait and watch and learn from future.
Absolutely. I think there is still ambiguity, is what I'm hearing, even from the way the webinar has taken shape today. And some of the clarity, still needs to come about. But with whatever clarity we have, thank you so much, both Madhu and Sandeep, for bringing this to light on both the OSH as well as the IR codes. And thank you all for joining in for this webinar. This webinar will be recorded. Yeah, thank you all.
Thank you. Thank you very much. Thank you, Sandeep. Thank you, Sanya.
Thank you. Thank you.